Hi, everybody. This is Luiz Morales with the Morales Real Estate Group. Welcome back. This is episode number 14 of the Luiz Morales Show. Today, we've got a very special guest. His name is Jeff Murphy. He works for Chicago Title. The topic for today's show is we're going to be getting into what are the different ways that somebody can take title to a property. In other words, what are the different ways that somebody can take ownership? So welcome to the show, Jeff. How are you?
I'm doing great. Thanks for having me.
Awesome. Let's start off the show. Tell me something good.
Something good. Well, let's see. The Lakers are playing really great right now. It's been a long time for that since that's happened. My Cowboys, I'm a Dallas Cowboys fan, so we're in first place. That's pretty cool. Christmas is coming up. Yeah, lots of good things happening.
That's great. So for all the Cowboys fans that are watching this, root for your boy, Jeff Murphy. So the reason I wanted to have this is because when somebody's buying a property, Jeff, oftentimes the escrow company will ask a buyer, how do they want to take ownership of the property, or how do they want to take title? A lot of the times the buyers don't really know what to do or what are the different implications that come with how you take title. So I wanted to ask you as a professional, what are the different ways that somebody can take title or ownership to a property?
Well, the most common way is joint tenants. That has a survivorship. So if one of the joint tenants were to pass away, their interest passes to the remaining joint tenants. There's tenants in common, which you can specify interests, and their separate interests pass to their heirs. There's also, you can pull title in a trust, partnerships, LLCs, corporations. It just depends how you want your remaining interests to be passed, either to the remaining joint tenants, family member, however you want that to be.
So let's get into that. You said that the most common way is joint tenants, right?
Yes.
So if somebody passes away, what happens in that situation in a joint tenancy? Like let's say there's two people on title, one of them passes away. What happens?
That interest goes to the remaining surviving joint tenant. So I own a property with my brother as joint tenants. I pass away. The property is now vested to him. He has 100% ownership.
Wow. So it doesn't go to their beneficiaries or anything like that?
No. It's joint tenants has a surviving, basically it goes to the surviving tenant.
Okay. So essentially, I mean, if you're a husband and a wife, it sounds like joint tenancy would be pretty good, because if a husband passes away, the interest goes to the wife. If a wife passes away, the interest goes to the husband. However, it sounds like if it's between a family member, like a brother and a sister, or a friend and a friend, then what do you normally see in those situations? Do you still see joint tenancy, or do you see more or less tenants in common?
You can see usually tenants in common. Specified interest 50-50, 70-30. And because what that does is the person who passes away, their interest goes to their heirs. So if you have children, your interest would go to your children.
Okay. So essentially, I mean, for the viewers out there that are watching this, I mean, when you're taking ownership or title to a property, I mean, it's something that you really want to ask more information to your title representative or to the escrow company and kind of run these different scenarios. Because what I see sometimes when we take ownership, we don't think about what happens if something else happens. And unfortunately, that has some sort of consequences. So let me ask you another question. Now, in joint tenancy, let's say it's a brother and a sister. What happens if one of the owners wants to sell and the other one doesn't want to sell? I mean, can one of the parties sell without the consent of the other one?
Well, that would take basically a partition sale. You'd have to, that's a court-ordered sale, where basically one would be, you'd have to present your case to the court, and then if it goes through, then it would be a partition sale, and that other party would basically be forced to sell at that point.
Is that the same with the tenants in common, essentially? If, like, let's say one of the owners wanted to sell and then the other one didn't?
Yes, that would be just about in any case, whether it's joint tenants or tenants in common.
So essentially, I mean, for the viewers watching out there, if you're taking ownership to a property, I mean, how you, whoever you have on title makes a difference. Because I see sometimes, and you probably see this more than I do, that sometimes people will add a dad, an uncle, an aunt to the title of the property, not really knowing the true implications of what that does. Have you seen that, or do you see that happen sometimes,
Yeah,
Jeff?
we see that quite a bit. Usually, when you acquire a piece of property, there's a lot to think about.
Mhm.
It's part of your estate, so maybe you should include your CPA or your attorney because it's and come up with some kind of estate plan.
Fine.
Um, how you want this property to be part of your estate and what happens to it if you're no longer able to control what's going to happen to your property.
Well, here's one of the not the problems that I see sometimes, Jeff. I see a lot of confusion in the marketplace. A lot of times people think that being on the loan means that they're on title. So it's like, for example, like somebody co-signs for somebody and they're on the loan, but then at the time of closing of escrow or shortly after, they take them off the title. So what is the difference? What would you say is the difference between being on the loan of a property and being on title?
Well, on title, you are part ownership. You have part ownership of the property. If you're if you're a vested owner and you're on the loan, you own the property and you're responsible for the loan. If you're not a vested owner, but you sign as a co-signer or a non-vested owner or non-vested spouse on the grant deed, you're still responsible for the loan, but you have no rights to the title to the property.
Yeah. Yeah. So this is where I'm seeing it more or less, Jeff, and maybe you can elaborate a little bit on it. I'm seeing it more or less like on divorces. Like sometimes somebody will say, well, my wife is just going to take over. My ex-wife is just going to take over the property. I'm just going to sign my name off of the property, off the title, and I'm just going to deed the property off to her. Now, what I've seen is that essentially what that is saying is I'm still going to be responsible for the loan, meaning if she misses a late payment, that person is still responsible, but essentially they're not on title of the property. So if they ever wanted to sell, I mean, they have more limited options because they're not on title, right?
Right. Once you go off a title and you're still on the loan, then yes, your responsibility doesn't go away as far as the loan does. Now you don't have any control of the property.
Yeah.
So if the other person doesn't want to sell it, they don't have to. So
Yeah.
basically, you have no ownership, but you're still responsible for the loan.
Yeah, which is kind of like not the position that you probably want to be in as a consumer, because you're still responsible for the debt, but you've got no interest in the property whatsoever.
Right. And the lender could, depending on what's written into the loan, uh, that might not be okay with the lender as well if one person deeds off.
So let's elaborate on that, because in the down market, like 2009, 2010, 2011, I was seeing a lot of like companies coming in here and promising people that if they deeded the property to them, that the problem would be solved, and we would see different people be added to the title of the property. Some of it, I think, was tactic to stop foreclosure. But do you remember what I'm talking about? And the problem that would create on a title of a property?
I do. There was basically just what you said was to cloud the title so it could not be foreclosed on. But what that does, if you ever want to sell your property, now you have all these other interests, all these other people who have an interest in your property. So now you have to consider all of them as well. Liens, judgments, anything that attaches to them is now attached to the property. It would have to be cleared up before you could sell the property.
So elaborate it a little bit more. What is called what is clouding the title? What does that mean for the consumer?
Clouding a title is would be anything that would keep you from selling your property or refinancing the property. Somebody puts a lien on your property that could cloud the title. A pending action. Basically, what it's designed to is to keep you from selling the property, or if you do, they get paid. So if somebody puts a judgment on your property, a money judgment, you have to deal with that before you can pass clear title onto somebody.
And a lot of times consumers, when they open up escrow, I deal with this from a real estate perspective. they're very concerned sometimes, like in probates, divorces, and other type of sales. They think that um, that their concern is that person going to be able to deliver clear title to me at closing, like in a probate or a trust. That's one of their concerns. What is used to protect somebody in a regular escrow or in an escrow transaction to make sure that the buyer does get clear title to a property?
And that's where our title company comes in. We search out the properties. So we search out the owners, see if they have any liens, judgments, what loans are against the property. It's our job to make sure everything's cleared. So all the judgments that are recorded against the parties are made of record, and they're paid off before they close. All the loans are paid off, taxes. So basically, so when it closes, the new owner, the buyer, is only subject to their new loan, or if they're not taking any loans, and they're not subject to anything else that was there prior to any liens, judgments, loans, taxes that were the responsibility of the seller.
So essentially, for example, like on a regular escrow, if it goes through escrow, all of this research is being done by the title company in the escrow, correct?
Yes.
What happens if like somebody wants to sell owner to owner? Like, and can they sell owner to owner without an escrow company? And is there any risk to doing something like that?
Yes. You mean just like a for sale by owner? They're just two people they decide one person wants to buy another property from somebody else?
Uh-huh.
Okay. Well, then they need to, well, I hope they do their own due diligence. Otherwise, they're just buying a piece of property based on somebody's word. That's where title and escrow comes in, is we do all that work for them and search out the condition of the property and let them report to them exactly the condition of the property.
So by going through an escrow and a title company, essentially it protects them to make sure that they're going to get clear title at the close of escrow, as opposed to maybe if someone buys a property directly from someone and they don't want title insurance to save a couple of $100 or whatever, they could essentially buy a property that has a cloud on the title, or that maybe doesn't have clear title. So if it ever comes time to selling it, they could be in a position where now they have to go back and clear that up.
Yes, exactly. Yeah.
Do you ever get situations where maybe there is a cloud on the title and you have to clear that up prior to the close of escrow? I mean, how often does that happen, and what does that process look like?
Well, clouds could be a judgment. Let's say somebody records a judgment against you. We need to order a demand and pay that off so that you'd have clear title. There's lots of different ways. There's state tax liens, federal tax liens. That's where the title company comes in, because we search all the records. We find those records and then make sure that those are all paid off.
To make sure that that's paid off. So essentially, when somebody opens an escrow, they fill out a form called the Statement of Information that asks for the name, date of birth, social security number, addresses, jobs. And then how does the title company use that to look up any potential liens, judgments, or anything that would affect the title of the property?
Liens, judgments, they're posted against a person's name. So when you run a person's name, you can get all kinds of, especially if it's a common name, you can see a lot of recorded liens, judgments. So we use that statement of information to eliminate those liens or judgments. So with a social security number or prior addresses, you can go about eliminating those items.
So does it ever happen where somebody thinks that they've got a certain amount of equity in the property, and then they realize that they have some sort of IRS lien, child support lien, or some type of judgment that really minimizes that type of equity?
Oh, yes. Yes. Yeah. You can see some pretty large, especially federal tax liens for prior years. State tax liens can get kind of high. But sure, yeah, it'll definitely can cut into your
So essentially, if somebody has that type of lien, they can't close escrow unless they deal with it, right?
Correct.
And the different ways of dealing with it are A, paying it off, or B, negotiating something with them, or getting them to give you some sort of release, correct?
Right. Let's just take a federal tax lien. Basically, you need to pay it off. You need to remove it from the property, and by doing so, you have to pay it off or get it released from the property. But the IRS would have to release it. So basically, maybe the lien wouldn't go away, but they're releasing the property from the lien, and that's what we need to do.
That makes sense.
So
So
either pay it or get a waiver to release the property from the lien.
So good practice from a real estate perspective would be to, whenever you take a listing, to begin the research process by getting a statement of information so that you can prevent potential problems. Have you ever seen this where it comes up a week before the close of escrow or 2 weeks before the close of escrow when everybody's packing, getting ready to move?
Unfortunately, yes. Some things come up at the last minute. For whatever reason, sometimes you don't get the statement of information till the very end. Things come up, but it's really important that people just be honest at the very beginning. If you have a lien or judgment or something that needs to be dealt with, it's best just to say this is what I have, so everybody can get to work on clearing that.
So it may not show up on title of the property, but once you run the names, that's essentially when it comes up, right? Once you run the names, the social security number.
Right, correct. Anytime you run somebody's name, it's a judgment or a lien. It attaches to everything they own. If they own more than just one property, it'll be on all their properties. It attaches to everything.
So what are the different types of liens that you see sometimes? I know child support is one. I know that tax liens is another one. What's something else that you would see on a title of a property that would come up?
Right, there's federal, state. There's also county liens. If you've owned a piece of property and were issued a supplemental tax bill and you didn't pay it, it goes to unsecured tax lien. You'd have to pay that. You can get an unsecured tax lien for a boat, a jet ski, anything like that, a business, all kinds of different types of liens.
Do you ever see people try to maybe deed the property to somebody else or take themselves off title to try to avoid some of those items?
They do, right? They do. They might know that a judgment's going to be recorded. They might in the deed off the property, but that's just to avoid the lien. It doesn't make the lien go away. That just means you're off the property, but whoever's left is still attached to the property and has to be paid off.
So essentially, it's still attached to the property at that point, even if they deed themselves off the property. So if people will try to avoid that type of stuff, thinking that they're outsmarting the system, but it doesn't really.
No, it doesn't. It doesn't solve their problem. They still have to pay it.
Yeah. Okay. Let me see. What is the process of somebody taking themselves off the title of the property? Is there certain paperwork if somebody wanted to do that, or if somebody wanted to add somebody else to the title of the property?
You can do that by a grant deed if you want to add somebody to title or take someone off. If you're going to add somebody on, it's important to know that now that they're on title, any liens judgments will now attach to the property.
So that's important too. If somebody adds somebody on title, like a father, a cousin, a fiance or something, now if they have any liens, now if they ever want to sell them, that affects them as well too.
Right.
Wow.
They could come on to title and come off a title a year later. It doesn't matter. Anything that they had, any lien or judgment that they had, is now going to be attached to that property.
Wow. Is there a limit to how many people can be on the title of a property?
No, you can have as many people as you want.
Yeah. Wow. Okay. And so I've heard about this before. So sometimes people will be on the title and they won't get so is there a way that maybe somebody could sign a grant deed or add themselves on title or take themselves off title, but then not do it the right way? So for example, maybe not do it through insurance or I don't think I'm.
Well, yeah, people add people on and come off title all the time,
Uh,
and they can misrepresent their interests that they possibly had. You know, maybe they had a third of an interest and they need 50%. Um, let's see what else they could put the wrong legal descriptions on there. I mean, there's people who don't know really what they're doing. Yeah, can make all kinds of mistakes, and that causes problems when they do want to go to sell because now you have to. Anytime you deed and it's uninsured, now we have to make sure that that party who deeded off or deeded to you um, meant to do that. So if I deed a property over to you, it's uninsured. You go to sell the property. A title company is going to want to make sure that that's what I meant to do, is to deed the property over to you, and that eliminates forgeries and other things like that.
so is that done mainly to like maybe somebody that doesn't know what they're signing, that they don't know that they're deeding themselves off the property? Is that meant to prevent that type of action?
Yeah, it's meant to protect everybody, just to make sure that um, there's a clean chain of title. That that person, when they signed that deed, knew what they were doing, and that's was their intent, was to deed their interest over to that person.
Now, let me ask you this. This is kind of like devil advocate. What happens if the person knew what they were doing, deeded the property off to somebody else, but they didn't do it through title insurance? Title would have to go back to that person and make sure that that was their
Right.
intention. What happens if that person all of a sudden says that wasn't my intention to deed the property off to this person?
Well, now you have a cloud. Now you have a cloud on.
Wow. Okay. And in that case, the right way to do it would be, if you're deeding the property off to somebody else or adding some, uh, removing yourself from the title, would be to get title insurance, right? Or what would the right way to do it? What would the right way to do it be?
Well, the right way would be through a grant deed, and you don't always know if you know what's going on in the situation. So it really is a case by case when you look at an uninsured deed. Uh, if you question it, or in your case, that example you gave, and somebody doesn't want to sign it,
Uh-huh.
then there's a story, and now you need to really do your due diligence and find out what the situation is. Most cases, if it's two brothers and one signing off, it's probably okay. It's just really a case by case basis, and that's where your instincts come in, and you have to ask questions.
That's awesome. That's great. Okay. So essentially, but if they do it through insured, if they insure the transfer, then at that point there's no need for the research, right? Or is there still need for the
There,
research?
there's still going to be research.
Okay.
We're still going to ask the same. If it's insured, it's usually through a transaction, so there's money. There's money being changed hands, and it's basically a transaction at that point, like a sale. If one person is coming off, um, yeah, we'd still ask the questions why and
Yeah.
why they're
Okay.
deeding up.
Now, sometimes people do owner financing, like sometimes on land, sometimes on properties that maybe are a little bit more difficult to finance and the property's paid off. Once you pay off the property, what does that process look like? Should the owner of that property be giving you any type of document? And is there a right way of doing it versus a wrong way of doing it?
Are you talking about like a seller carryback? Is that
Yeah, like let's say that the owner does financing, like
okay?
carry back on a property. Once you get done paying that off, like in a normal transaction, the bank gives you a reconveyance, I believe, right?
Right. Correct.
Is there,
The same would apply in this case because they would record what they call a deed of trust,
mhm,
and they record it concurrently with the deed. And once that's paid off on the deed of trust, there's a page to sign for the beneficiary that it's been paid off, and they
mhm,
sign it. And there's two ways of doing it. They can either execute a substitution of trustee and full reconveyance, or they send all that the note and the original deed of trust to the trustee, and the trustee would issue a reconveyance.
Okay. If I'm buying a property as a married person, can one spouse only be on title and not the other one?
Yes, but the spouse that is not going to be on title would need to execute either a quitclaim or an interspousal deed.
Huh?
To So if it was your wife, she would execute a interspousal deed to you as a married man, sole and separate property.
Okay. So essentially, one of the spouses could be on title versus the
Yes.
other person. Okay. Can someone add? And I've got a list of questions. That's why I'm looking down.
Sure.
Can someone add a lien to your property without you knowing or without your permission, essentially?
Correct. That's called an involuntary lien, and that would be a judgment, um, a federal, state, or county tax lien. It's usually for non-payment, so that's what they do. They put a lien on your property, and that attaches. Well, they put a lien on your name, and that attaches to your property, everything that you own, and that's where the title comes in because we search that out and then make everybody aware of those. So all of those get paid off.
Those get paid off. Okay, great. And then the last thing I wanted to touch on is we talked about tenants in common. We talked about joint tenants as well too. Can entities own property as well too? And what are the different types of entities that could own a real property?
Entities, sure. LLCs, corporations, partnerships. So it's the entity that owns the property. So in our case, we need to make sure who's signing, who's the authorized signer on behalf of a corporation, an LLC, a partnership. So at that time, we would ask for those types of documents. Like on the LLC, it would be an operating agreement that tells us who the managers are of the property or the LLC, and they would be signing all the paperwork.
That makes sense. Okay. And why would somebody own a property in an entity instead of like maybe doing like a joint tenancy or something like that?
It's could be for tax reasons. They just want to own it as a business. Usually it's for taxes, and there might be multiple people within the LLC who put in a certain amount of equity dollars into the LLC, so
Yeah.
they can buy more with pool their money.
That's great. Cool. Cool. Danita Barroso from Contact Escrow just said, "Hi guys."
Hi, Danita.
Good. So I would say that I asked all of the questions that I thought would be important for consumers to know. Is there anything else that you'd like to add, Jeff, that you feel would be helpful to consumers out there when buying and selling properties?
Oh, sure. I mean, it's a big, huge investment. Lots to think about. That's what we're here for, Chicago, and then everybody who does title and escrow is to help them through it. It really is a big decision. It's part of your estate, a lot to think about. But at the same time, that's what we're here for. So we can always make it as easy and as possible for them. Just want to give us a call, or any way we can help them. But yeah, it can be tough and complicating and a little scary sometimes. But that's what we're here for, is to explain everything.
And just for the consumer, so that they know, this is a lot of the stuff that happens in the background. This is a lot of the stuff that sometimes the consumer doesn't really get to see, that a title representative or a title person is doing in the background, just to ensure that the property has clear title at the time that the new owner takes possession of the property. So just a little bit of inside knowledge. So I appreciate having you on the show. You are episode number 14, and I hope that it helps a lot of people out there. So thank you so much.
Yeah, thank you.